Alrighty, welcome everyone. Thank you for joining us for our April Ascend webinar. This month we have Dr. Ellen Purpose. Dr. Purpose is Assistant Vice President of Enterprise and Innovation at the University of Nevada, Reno. She will be discussing conflicts of interest and the importance of managing real and perceived conflicts to protect students and patients and avoid running afoul of policies, laws, and the court of public opinion. Dr. Purpose will go through her presentation, and then we will leave about 10 minutes at the end for questions. Please send them through the chat feature, and we will read them out loud. Thank you, Dr. Purpose.
Oh, it's my pleasure. I'm happy to be here. Thank you for the invitation and the opportunity. So, and hello, everybody. I can't see you at this point, but I know you're there. So thank you all for tuning in. A couple things, couple of caveats at the beginning. I am not an attorney, and so please don't take any of this as legal advice. And also, I'm more of a tech transfer startup person. Part of my team in Enterprise and Innovation is the tech transfer office, and then we also have a couple of incubators and the NIST MEP Manufacturing Extension Partnership for the state also falls under me. But my point being, I'm not a conflict of interest specialist, but I have sat on conflict of interest committees. I counted up at 3 different institutions. And I'm actually on 2 COI committees here at UNR, one for individual and the other for institutional. So, that's my street cred, such as it is. But again, this is not my specialty, but I will do my best to give you some basics and some thoughts and ideas. And then certainly we can get into a discussion at the end. So you'll see in the slides every once in a while, you'll see a reference. And I just wanted to put those in there because it's appropriate, but also so that you could go to these references and look at what they had to say. And I did get a lot of information off of one of the SlideShare COI presentations, and that was very, very useful. It's a great slide deck, and I encourage you to look at it. So in here, for today, I'm going to talk about, obviously, COI and conflict of commitment. That's what COC is. Give you some definitions of both and some examples and how to manage. And then I'm going to touch a little bit on institutional COI, not too much. And then the last slide is just a set of resources, some websites that you can use if you want to learn more about COI and its management. So why is it important? And Hallie alluded to it in her introduction. We in academia have quite varied opportunities for research and to be entrepreneurial. Faculty can potentially benefit financially and otherwise, from these opportunities. We need to make sure that the science remains sound and isn't subject to bias. Obviously, we need to protect human subjects and patients in general. And right alongside with that is preserving public trust. And I gave 3 examples here that you've all probably heard of. The Tuskegee study of syphilis in the adult Negro male, where they actually docs said that they were treating or told these patients that they were treating their syphilis when they actually were not, and they watched the course of the disease in these individuals. And then there's the the HeLa cell line, which actually came from Henrietta Lacks. She was suffering from cervical cancer, and her surgeon was trying to establish immortalized cell lines, cancer cell lines, and Ms. Lacks, actually, her cells ended up being the most robust, and they are a hugely important research tool. But it wasn't until the book came out several years ago that Ms. Lacks got any credit or any recognition for this. And it spurred continued conversations about patient trust, patient consent, Ms. Lax didn't know any of this was going on. And if I'm totally blanking on the name of the book, but it's a great book if you want to read it. It gives the history of how Gila came into play and the aftermath. And then the last example is from Willowbrook School in Staten Island. And this was an institution for intellectually impaired children. And actually, just as a little bit of trivia, it was a horrific place. And the public learned about Willowbrook and its practices from an expose done by Geraldo Rivera when he was first starting in his career. So that's your trivia for the day. But they also, they conducted hepatitis studies. They deliberately infected children with Hep A. And then they watched the course of the disease. And then they administered gamma globulins to see if those would treat the disease. And so another failure of trust. Going further on this list, we have to be able to have free and unfettered reporting of results and discoveries, the whole academic freedom thing. We have to protect students and their progress through their courses. And last but not least, most funding agencies, certainly state and federal, require the institutions to have COI and COC policies and mitigation plans. And I've seen in some instances where private foundations require those things as well. Also, accrediting organizations such as AHARP require robust programs. So is conflict of interest bad? No, not at all. It should not be equated with scientific misconduct. Most conflicts can be managed. And we have an issue of perception versus reality. And there in some quarters, people feel that that conflict of interest is automatically bad, and that whoever is conflicted is inherently dishonest. And nothing could be further from the truth. That said, perception is reality in many cases. And so the institutions have to be able to protect the faculty and the staff to manage those conflicts and maintain scientific integrity. So what is COI anyway? So the official designation or definition is it's a conflict between one's private interests and one's official responsibilities if you're in a position of trust. So an example, situations where research activity may or may not or may be perceived to be compromised by financial or other interests, or where there's a potential to distort or a distortion of one's judgment because of financial or other interests. Can COI be avoided entirely? No. And we'll talk about that for in just a moment. COC, conflict of commitment, is essentially the same thing, but it has to do with your external activities, paid or unpaid, that could interfere or do interfere with your primary obligations and commitments to your institution. So is bias an inherent human trait? That's a difficult question to answer. And I won't go into a whole psychology discussion here. But we want to protect people because humans are humans and we all have human failings. At the same time, the vast majority of us want to do the right thing. But we can fall into traps at times. We love our pet hypothesis, our pet theory, and we want to validate it. We only want to use our positive data, our good data that support a hypothesis, and showing only those data in a publication. A reviewer may see a manuscript or a grant application from a competitor and may deliberately give negative input to torpedo that competitor's efforts. And then personal beliefs can influence objectivity as well. So types of conflicts: personal or institutional. Financial is the best known and the most common. And the ethical, of course, relates to scientific integrity, and related issues, patient protection and things of that sort. And the two are often closely intertwined, and the two may have to be managed. And I'd say 90% of conflicts can be managed relatively easily. The other 10% can be managed. It just is a little more complicated. There are a few absolutes, which we'll talk about, but in general, conflict isn't bad. It's manageable. So this is a definition that I didn't write, but it's very important in terms of the Office of Human Research Protections out of the NIH, and how patients are protected, and the thresholds for what represents a conflict of interest. And it's defined as a significant financial interest, an SFI, and that is anything of monetary value for services from an outside institution, any equity or stock interests, any intellectual property rights, particularly if one's receiving royalties. Those can give rise to SFIs. Generally, and it depends somewhat on institutional policy, it won't include salary. It may not include royalties or other IP remuneration from the home institution. SFIs generally do not include honoraria or income from seminars or lectures or teaching sponsored by public nonprofit entities, not by for-profits, or income from service, advisory committees and so on. That list can be varied, and it's not an absolute. And there are situations where something along these lines could become a conflict, but I'm not going to deal with those here today. So in general, the monetary threshold for disclosure of a potential conflict of interest is anything of monetary value that exceeds $5,000 and represents more than a 5% ownership interest in a single company, regardless of whether or not that interest or that equity is held in a company founded by the researcher or not. And this stretches through to the immediate family. So equity interests of spouses and children are aggregated along with the individual to determine, or to add into that threshold and determine whether or not conflict management is needed. A few examples, and this was taken from University of Pittsburgh. They have a very good website that's very helpful. And I suspect most of these, or if not all of them, but an example: accepting special favors or gratuities from companies doing business or sponsoring research at the university. So, I'm in charge of purchasing, and I'm going to buy something from Nuf Corporation, and they're going to reward me by giving me a car, or giving me, something less than that, but something at all. Accepting overscale honoraria, particularly when it's from a company. Sometimes they don't necessarily understand academia, and they will offer to pay exorbitant amounts for speaking, and that can be problematic, particularly if those companies could be affected in some way economically or politically by an investigator's research. Performing research for a company in which the investigator has a financial interest. Is it a COI? It could be. Is it manageable? Yes. Accepting a paid consultancy with a company having an interest in your research. And sometimes the consulting work can bleed over into the university work, and that's where you have to kind of pay attention. Using students to perform services for a company in which you have a financial interest. We hear about this primarily relative to spin-out companies where the PI in the lab is the founder of the company, and they have students work on matters related to the company, which can be okay. Again, it can be managed, but there needs to be disclosure and protection of the students. This is another committee that I'm on, the textbook adoption committee. So a lot of professors write their own books, they might assign their book for their students taking a particular course, but they might get some royalties for that. So that has to be dealt with in one way or another. Accepting research contracts with restricted publication. I'm sure you've always seen this. A sponsor may not want you to publish at all, or may want to have the right to redact any of your data or any of your conclusions, or those kinds of things. And that takes that takes research out of the research realm and puts it closer into the work for hire realm, and that's problematic for a number of reasons, which are subject to different discussions. But two, I mean, we're hired. I mean, our job is to disseminate information, and so we have to be very careful and very protective of our faculty to make sure that we don't inadvertently allow a research contract to restrict publication inappropriately. Excuse me. Giving privileged access to information that is developed or owned by the university to another entity in which you have a financial interest. So, an example of that would be, let's say you own 20% of a small business, of a startup company, and you give them unpublished data that could result in intellectual property or could be of value to that company. And then I alluded to this in the first bullet: negotiating on behalf of the university for the purchase of materials from a company in which you have a financial interest. And so an example of that might be you've created a spin-out company that now has a drug on the market, and you're negotiating with that on behalf of the university with that company, or the university hospital with the company for the university hospital to purchase that drug. Some more examples. Again, directly influencing negotiation of contracts. At UNR and every other institution at which I've worked, we do not allow the investigators to negotiate licenses or related commercialization contracts. They have to recuse themselves. They can't even be they're not supposed to be even in the background hearing about what the terms are and that sort of thing, because we want to protect them, because that would be an automatic conflict of interest, and it's not really fair to expect them to be unbiased. That would be very, very difficult. Another example: accepting a gift from a student who you have to evaluate or grade. If they give you, I don't know, an iPad Pro, you might be incentivized to, change that C to maybe a B minus, or worse. So this is a biggie. This next one is a biggie in clinical trials, and it's providing or receiving financial bonuses for meeting subject recruitment targets, or for achieving the results that the sponsor wants to achieve. Holding office or membership on a board or a committee in an entity supporting your university research. Again, that becomes an issue with spin-outs in particular. And the same is true for holding equity interests, including stock options in an entity that supports your research. At UNR, we allow spin-out companies to sponsor research in the founder's lab. Now, that said, there is a robust management strategy that's put into place for that. But we, with SBIR and STTR grants, for example, received by the spin-out company, they can be subcontracted back to the university. Another example could be receiving royalties or other proceeds. And again, in excess of $5,000. And if you impose restrictions on students or trainees, particularly with regard to publication at the request of a sponsor or your spin-out company or what have you, that's a definite COI, and it's an interference with that student's ability to progress in their career. So those are a gazillion different examples, and there are lots of different permutations of each. When you're evaluating COIs, they generally fall into one of three categories. And I say COI, I also mean COC. The first category is the conflict is not significant, generally permissible, no plan needed. Chances are pretty good that your institution has an annual COI disclosure requirement. And in a case as with A, we would ask the faculty or the staff member to disclose on their COI disclosure that this activity is happening. B, a potential conflict. It doesn't yet exist, but the potential is there, or a perceived conflict. And that's where the gray area is, and a management plan might be needed. It's very fact specific and situation specific. And then you have the category, of course, of an actual conflict, and a management plan is definitely needed, along with disclosure and monitoring to make sure that that there's compliance. Keys to managing COI or conflicts in general: transparency. Don't keep it a secret. Be transparent with the relevant parties. And then oversight. Make sure that there are objective, non-involved individuals who are assisting with oversight of whatever that situation is. So different ways to mitigate or eliminate COI. Again, disclosure mitigates a lot. You tell the institution, you tell the student that, yeah, you may have a financial interest in the research. You tell patients, and you see this on your informed consent forms, where it says, the physicians may have an interest in a financial interest in your treatment plan, including, drugs or devices and so on, and you consent to that. Of course, you disclose the funding agencies, and they have their own rules that with which you have to comply. And then most journals require COI disclosures, and you see this in the papers, in the first page of the papers, often as a footnote, that either no conflicts exist, or that the individual may have intellectual property related to the published materials and so on. And the same is true for lectures. Excuse me. The requirements may not be as strict with seminars and lectures, but for ethical purposes and to make sure that people see you as being above board, it's better to disclose. So disclosure, then oversight, the management plan. Management plan will cover a lot, and it will often cover numbers 2 through 5 in this list. You can recruit, or the individual can recuse him or herself from any decision making or supervising. An example would be a student being a PI founder, an investigator / founder of a spin out company, and a student is working on a project related to that spin out company. There may be a different supervisor in the department appointed to make sure that that bias doesn't occur. You can recuse yourself from being a PI on relevant studies. There can be monitors of research and data. Sometimes there's a disinterested third party within the department that will look at data or look at grant reports or at manuscripts and that sort of thing, just to try to make sure that that there's not bias. That's difficult because these folks are not as necessarily as deeply expert in the discipline in which the PI is working, so that can be tricky. And then lastly, you can have an external monitoring boards like data safety, or excuse me, patient safety, it should have said, and also data monitoring boards. Elements of a plan. So you describe the conflict in detail. You describe the process, not only for disclosure of the conflict, but the process for how that conflict is going to be managed. So, for example, a management plan may include appointment of an advocate in the department for students, so that your students can go to this objective advocate if the student has any qualms or any issues with their progress and they think that it might be due to conflict of interest. And again, there may be another advocate or another individual or the same person in the department, third party person in the same department though, monitoring data and monitoring your manuscripts, and making sure and working with you or with the investigator to ensure that they're not just showing the data that support the hypothesis. The department has to be committed, and the management plan has to reflect that, and it will generally contain a paragraph that says that the department is committed and that it will be doing X, Y, and Z to monitor and assist with compliance with the management plan. The plan will discuss sponsored research and how that works. So, I mentioned a few minutes ago that at UNR, we allow faculty spinouts that have received SBIR or STTR funding to subcontract back to the university. And so the management plans are put into place for that. And then how that is dealt with in terms of purchasing decisions and student management and management of employees in general, management of staff. And usually there's someone in the department outside the lab that is appointed to monitor, purchase decisions and student progress and so on. There's an intellectual property clause that makes it very clear that at least at UNR and most universities, any IP created using institutional resources belongs to the institution, and that the investigator pledges to disclose that intellectual property in accordance with whatever policies and procedures are present at the institution. The plan will talk about student involvement and what investigators can and can't do with students. They have to disclose to students that a conflict exists, and then the student has to know that he or she has an advocate outside the lab who can assist if the student feels as though the conflict is impinging on their ability to publish or make progress or what have you, or even choose the projects. And of course, the plan will talk about publication, no censorship, no denial of the ability to publish. That's a given in academia. And the plan will outline where you need to recuse yourself or where the individual needs to recuse him or herself. So for example, purchasing decisions. And that's generally significant purchasing decisions, deciding to buy, a restriction enzyme from New England Biolabs. That generally would not rise to the level of needing oversight. The plan will also outline how university resources can be used. In most universities, or let's say many universities, the universities are nonprofits, either designated by the state or the IRS, and so they're very careful about business use of university resources. because that can have an impact on their nonprofit status. So if the spin out using university resources can be problematic, and there are ways to get around that. So, for example, we have excuse me, here at UNR we have entrepreneurial wet labs where spin out companies can lease space. These are fully equipped labs. They can lease space and do their work, but those labs are located in a building that was not created through use of tax exempt bonds. And so business use is allowed. So, I won't go into a lot of detail here unless someone has questions. But a lot of universities don't have that kind of a facility. I think it's MIT has Lincoln Labs, which is they can do all sorts of business related research. So anyway, use of university resources, what you can do, what you can't do. Can you use the telephone? Can you send an email? Can you sequence DNA, and so on. Usually in the former, the phone and the sending an email, that's usually allowed if it's incidental use. And then, of course, what are the individuals required to disclose, and making it clear what they need to disclose and how to do it. People managing COIs live this stuff, and it seems intuitively obvious. Everything seems intuitively obvious. And the faculty, with their many commitments and many obligations, they may not remember how to deal with these processes. And so, it's our job, or the conflict manager's job, to help them remember and understand exactly what they're supposed to do. I've gotten lots of questions from faculty saying, "I don't know what to do. Help me." And then we just work through it. But they do need some help. Some are very savvy, some are not. And which I'm sure you've seen, and it's as service organizations, in tech transfer and in conflicts management, the faculty they're one of our customers, and so we have to take care of them and help them out. Without them, we don't have jobs. Absolute recusals or prohibitions. So let's say an IP creator, an inventor. I'm using a very generic term because it may not be patent. It could be copyright. It could be trademark, etc. So a creator generally cannot be PI on the clinical trial that's being conducted to test the drug that comes out of the discovery. There is a very famous case out of University of Pennsylvania. It's a very tragic case years ago where a young man actually died. And the IP creator was the PI on the trial. And, if you want more details or want to know the case, I can tell you either in the Q&A or offline. But it was a very tragic situation. And it's become a textbook example of how not to manage conflict of interest. Other absolute prohibitions, speaker bureaus. Most med schools will not allow their physicians or their researchers to be part of speaker bureaus. They don't allow ghostwriting. They don't allow gifts of any value. And here at UNR, it's not just the med school. We are not allowed to even accept a cup of coffee from someone who could influence our jobs. So it's interesting because the data, many of us think, well, that wouldn't influence me. A cup of coffee? Nah. But the data show that no matter how ethical we think we are, we do have a slightly more favorable view of someone or someone's company because of that cup of coffee or because of that really cool pen that we've received. It was remarkable when I read the papers, the bias, the unconscious bias that we all have, no matter, even if we think that we would never do anything unethical. It's quite startling. So Other prohibitions, industry marketing activities. So the institution just never wants to be seen as making an endorsement of a particular company's products, even if that company is a spin out. So that's one of the reasons you have the use of names provisions in your licenses and other agreements. But also the investigators should not be participating in industry marketing at all. So, for example, Dr. Nuf should not be appearing in a company's ad for a treatment for, I don't know, hangnails. It's again, it can undermine the perception of that individual's integrity, and that's their name, that's their good name, and that needs to be protected, and we will help them do that in one way by prohibiting these kinds of activities. Other prohibitions, nepotism and hiring decisions. You can't hire your mom, your wife, your grandmother, your kids, whatever. And generally, part of a management plan, or often part of a management plan, is addresses hiring decisions and who makes them and who approves them and so on. And then negotiations of agreements, we talked about that already. And then purchasing decisions, we've talked about that as well. So you just have to, they have to recuse themselves, and, they can, with purchasing decisions, they can give input, but they can't make the final decision. Okay, a few scenarios. And, I was trying to figure out a way to get some discussion going. And then realized that there might be either too many people in the webinar, or that we might not have time. So, and I know I think we're doing okay on time. So anyway, I'll just talk about these scenarios and what do you do? How do you deal with it? So, let's say an inventor or a creator of IP has I'll give you a real life example. So in a former institution, we owned a gene therapy technology, and that technology had to be administered through a very specific and touchy and difficult surgical procedure that only 1 or 2 people on the planet knew how to do. Our inventor was one of those people. So in order to, for the patients to be in the clinical trials, the inventor would have to perform the actual surgical procedure to administer the gene therapy. What did we do? A lot of things. There was oversight in the operating room. There was an outside patient safety monitoring board, and I say outside because they were not part of the institution, but they were on site quite a bit, making sure that the patient safety was tantamount, or was first priority, top priority. Again, oversight by someone without a financial stake in the IP. That one became difficult because we had an institutional conflict as well. So, but again, you use third parties, and there are ways to do it. Outside data monitoring board, not just the patient safety monitoring, but data monitoring. And then, of course, disclosure to the patients or the clinical trial subjects. So it's very rare that you're going to run into this, but it does happen every once in a while. And institutions are very motivated to make sure that any perceived conflicts or real conflicts are managed. So, okay, next scenario, inventor, IP creator has founded a spin out and wishes to do company research at the institution without sponsoring research, without anything. The investigator is going to do R&D or going to do product development in his or her lab. Well, you can't do that. So the company has to sponsor the research, and there has to be a management plan with data monitoring, student monitoring, IP, and so on. They can't just run their company or do their company's product development in their labs. And even sponsor for the company, the spin out company, to sponsor research in the lab, a lot of institutions don't allow that at all. Here at UNR, we allow it in certain circumstances, and I mentioned SBIR, STTR. The rest of the time, they need to have their own facility or lease space in our entrepreneurial labs in the building that I alluded to. Next scenario. The institution owns IP associated with the clinical trials to be conducted at the institution. In general, the institution will decline to be a site for the trials. If they have to be for some reason, like in scenario 1, you use external data monitoring and patient safety monitoring boards, you disclose, make sure that your funders, that the funding agencies are aware, not only of the conflict, but how it's being managed and so on. And then you might have an instance where it's the same scenario, but it might be that the institution is one of the few that sees a particular patient population that would be eligible and necessary for a clinical trial. So if there's some rare disease where the institution is an expert in treating that disease, and everybody comes from all over the world to be treated there, then you're not going to be able to find patients elsewhere. So the institution can't really recuse itself. And so, again, disclosure, transparency, monitoring data, monitoring patient safety, notifying funders, notifying the FDA, making sure FDA is happy and comfortable, all of those things. So you'll see, the pattern here is transparency and oversight. And and as I said earlier, those are the keys to managing conflict of interest. So I'm going to move on briefly to institutional COI. It's pretty similar to the individual COI, but it's where the institution's financial interests or individuals with authority to act on behalf of the institution's financial interests may affect or appear to affect decisions made by that institution and that are related to its missions. And in the second example, where it's for individuals with authority to act, they are probably going to be subject to individual COI management as well. So how does this get managed? In general, these the management begins in the president's office or the chancellor, whatever you call the head honcho of your institution, and he or she will most likely designate individuals or a committee to monitor and mitigate institutional COI. There's usually a list somewhere that names the individuals with the authority to act on behalf. It generally includes deans. It might include department heads. Certainly, provosts and vice presidents and assistant vice presidents. There's, here at UNR, I think we have a list of 72 people. And that can change, periodically. So the policies are generally, they originate in the president's office, and his or her designees will monitor and mitigate. So where they might exist, substantial gifts from research sponsors. So I was at another major university years ago, and I was helping sponsored projects negotiate a research agreement with a large company that was also a major donor to the university. And as part of that sponsored research agreement, that SRA, that company wanted to own intellectual property that came out of the research, and the company wanted to be able to control publication. And of course, we said, well, no, you can't because of these reasons. And first thing out of their mouths was, we're major donors. You need to make, concessions for us, or we're going to cut off the money. That could be an institutional conflict, because you have, the need and the desire to bring dollars into the institution, and for lots of good reasons. But at the same time, the research has to be free and unfettered and free of bias. So that's something that would need to be managed by the institutional COI committee. Major institutional purchases. Let's say, this is a silly example, but let's say that I own Toyota, and I'm pushing, or I decide to sign the purchase order that where our university buys a fleet of Toyotas for their vehicle fleet. That might be a problem. And in theory, I should, not in theory, in reality, I should be recusing myself from any of those purchasing decisions. And then tech transfer arrangements. And I'm using that term very broadly because it can be licensing. It usually is licensing, and it can have to do with equity or with royalties or what have you. I will tell you, too, that in my experience, I've come across conflict of interest officers who are kind of inherently biased against tech transfer, because in reality, our job is to create conflicts. Now, I say that to certain people, but then the next part of the sentence is, and we are tasked, or we need to help manage those conflicts. So again, tech transfer sometimes has a less than stellar reputation for whatever reason, based in reality or not. So, be aware of that, and make friends with your COI folks and offer to help them and help them understand. A lot of times they've not been exposed to business or licensing, and they may need some education, and be willing to coach them and to help them with that. That'll get you a long way towards making sure that things are managed in a realistic and practical manner. But again, you can have institutional conflict. We've licensed IP that could be used to treat hangnails, and the clinical trials are going to be held here. Well, no, we should probably recuse ourselves. So, and a few examples of institutional COI, and this is from University of Minnesota. Again, like I described, I own Toyota, and then I want to have the university buy a fleet of Toyotas. That would be a prime example. Again, university licenses an invention or IP to a business entity, where that entity could affect university research or other activities. And again, that's a management issue. That relates somewhat to investigators doing company research in their labs, and protecting students and all of those things. I mentioned this. You heard this a couple minutes ago. University vendor. Excuse me. That was a sponsor. University vendor donates a gift to the university. So, a vendor. I don't know. Someone who sells paper to the university, and they also make a big gift to the university. And that can introduce some bias. Well, maybe we should buy our paper from them. Well, maybe not. Again, that needs to be examined. Same for investments or holding equity in companies that may have a business relationship with the university. Commercial transactions that might compromise or appear to compromise the university's teaching or research or any mission activities, or the reputation. Again, public trust. If we lose public trust, we are toast. And I mean that because we'll lose students, we'll lose credibility, we'll lose research funding, and it's just not a place where you want to be. And then lastly, we've talked about this also. University has an SFI in a business that is going to be conducting clinical trials at that university. So let's see. Oh, sorry. And I'm going to stop there. Again, this is a list of resources that you can utilize if you feel the need to learn more about this. And again, I'm not the end all be all to COI management, but if any of you have questions or need some advice or help or just need to brainstorm, just drop me an email. I'm happy to always happy to talk. And I believe Hallie is going to be sharing these slides either on the Ascend website or with the attendees. I'm not sure how. She'll tell us. And with that, I'll say thank you very much for your attention and your time. And I hope this was helpful for you. And now I'll turn it back over to Hallie. And where is Hallie?
Hallie may be having some microphone issues.
Okay.
So I'll go ahead and take over from here.
Okay, that sounds good.
So the slides are actually currently shared in the files section of this webinar, so you can download the PDF directly from there. And Ellen, would you mind turning off your mic while I'm speaking? I can kind of hear a little echo. Apologize for that.
Yeah.
Great. All right, so if you have any questions, please feel free to post them in the chat. And thank you for that presentation, Ellen. That was very informative. I learned a lot, and I'm sure all the attendees did as well.
Is this better?
Yes, that's much better. And we do have a question in the chat already from Shelley. And she asks, it's a little bit of a long question. Can the speaker comment on how COI related to nepotism married individuals?
So can you hear me? How is this?
Yeah, we can hear you. Hello? Can you hear me, Ellen? All right, we appear to be having some technical issues. Give us 1 second to try and figure this out. Apologize for the inconvenience.
Okay, I have the sense that there might be some technical difficulties. Actually, if I knew how to get into the chat, let me see if I can figure out how to do that. And then I could start with the questions, but I don't have that ability. Let's try this. Nope, that doesn't help.
Can you hear me now, Ellen? All right, so seems like the chat can hear me.
Sound like Pink Floyd. Is anybody out there?
So it seems like the participants can hear me, but it seems Ellen can't. I'm not exactly sure what is going on. Hallie, is your microphone working by chance?
Hi, this is Kathy. Can you all hear me?
Yes, we can hear you, Kathy.
Okay, great. Hi, this is Kathy Foster. I am the program manager at Ascend, and so we are having some technical difficulties right now. Let me see if I can get in touch with Ellen.
Well, if anyone can hear me, I apologize for what's happening. I don't know what's happening, and it could be that I'm just not receiving audio. But I certainly would understand if you sign off or want to sign off, and you can email me your questions. Okay, Hallie, I don't have 3 dots on other. Wait a minute, I'm sorry. I lied. I do have 3 dots. Let me see if I can find the chat. Okay, good. And no, I did not turn off my speaker. I did turn off my microphone, but anyway. So I see one question that says, we are applying towards an SBIR in CRADA, with a national lab that they're likely to work with, have an NDA, but doesn't know if they have a COI form to sign. Is that normal? Every national lab with whom I've worked is subject to the federal conflict of interest policies, and they will have, they should have all of that information. And if they don't, actively ask the person in their sponsored projects office, because they should have all of that. Let's see. Question, can I comment on how COI related to nepotism can be managed when research is not involved? Let's say one spouse is an associate dean and the other is a department chair. Should the associate dean be left out of all conversations that involve the department chair's department? Shouldn't they be allowed to provide the exact same sort of input they would be allowed for any other department, just not make the final decisions? I don't have a good answer for you. I do know that associate dean would not be permitted to supervise, to be the department chair's supervisor. Beyond that, I apologize, I don't have the answer to that question. The Immortal Life of Henrietta Lacks is the book. Thank you. And that's all I see. So again, thank you for your attention, and yeah, have a great rest of the day.
All right. Thank you, Ellen. And thank you everyone for joining our April Ascend webinar. The recording for this webinar will be on the Ascend website, ascendhub.org, next Monday. Also, please join us next month for a presentation by Dr. Graham Timmons at the University of New Mexico on entrepreneurship. You can find the registration link on our website as well, ascendhub.org. Thanks again, everybody, and have a great rest of your day.